Hello and welcome to today's Market Tracker Talking Points video. I'm Kavita Basson, a lawyer at Lexis PSL at LexisNexis, and I'm joined today by Selina Sagayam, International Corporate Finance Partner at Gibson, Dunn and Crutcher. Hello Selina.
Good morning, Kavita.
Today we're going to be talking about a couple of public M&A trends which we discuss in our Market Tracker Trend Report. And we're also going to be discussing some of the fallout from Pfizer's hostile takeover bid for AstraZeneca earlier this year. Selina, our Market Tracker Trend Report notes that, that the number of non-UK bids for UK listed companies have been off the charts. They've really dominated the public M&A sphere in the first half of the year. What, in your opinion, is the reason or the reasons for this trend?
Mm-hmm. I think we have seen actually for a number of years now an increasing number of non-UK or let's call them foreign bidders looking at UK target companies, driven in part by I think in fact primarily by the transparency of the UK's financial services system, the open economy, and the fact that in relative terms, at least compared to many European countries and European targets, undertaking a bid for a UK target is relatively definable and clear. In addition, of course, I mean, this year we have seen the gradual but steady recovery out of the global financial crisis, in particular with the US leading that recovery, and hence there is more cash coming out of that part of the Atlantic looking for a home and for new investments.
Okay, great. That makes sense, and that's sort of what we've been anticipating at LexisNexis as well. A particular feature of the first half of 2014 was a high level of bid activity, which has been fueled by inversion tax planning. In light of recent comments by the Obama administration in relation to the use of the inversion tax planning structure and of tightening this loophole, do you think we'll continue to see this continued interest by US companies in UK listed companies?
It's an interesting question, and I think the crystal ball indicates that there is certainly going to be a muting of that activity. But perhaps a few words on what are actually these sort of inversion deals. A reminder really for your audience. I mean, the US has one of the highest corporation tax rates in the industrialized world at around 35%. And to compound that clear business hit, the US tax system means that US corporations are actually taxed on their global revenues. And so that includes and captures income from their non-UK, non-US rather, subsidiaries. Mm-hmm. This has been clearly a key issue for many US corporations, and over the years, many have sought to try to avoid and get out of this global tax net that the US imposes. By way of example, in 1960, 17 of the world's, out of 20 world's largest companies were actually headquartered in the US. By 2000, that number had dropped down to 7, with many companies actually using methods to avoid it. And the first route they chose was to simply interpose a non-US incorporated company at the top of the group and thus make it a non-US group. Mm-hmm. That was buttoned down by the US government in 2004, and legislation was introduced to close that loophole off. However, there was still an ability to mitigate the impact of the global taxation system by using the so-called inversion transactions. And effectively that means that if a US company were to combine or merge with a non-US corporation, and if the US shareholders held less than a certain percentage of the enlarged and combined group, that group would no longer be subject on a worldwide basis to US corporation tax. You'd look at the relevant entities which were US domiciled, but you wouldn't be taxing necessarily the whole group. Mm-hmm. And the relevant threshold in terms of the two relevant thresholds was as long as the US shareholders didn't hold 80% or more, they would not be regarded as a US group. In addition, there were certain tax consequences if US shareholders held between 60% but less than 80%, but still not as heinous as if you held more than 80%. So that's the sort of backdrop, and that's what the inversion concept means. Now, in spring, I guess, in May, and the Pfizer bid for AstraZeneca probably being one of the more recent triggers, there was more statements coming out of the Obama administration about the fact that they really needed to close down this loophole and stop the exit of even more US corporations. And changes were really trailed in July of 2014. And what we saw, though, in September of this year was the US Treasury and the IRS issued a statement, a notice, which has sought to close down most of the loopholes around tax inversions. What they've done is effectively to make it much harder to get out of the US global tax net. And what they've also said is that the new rules will apply to all deals which are going to close on or after 22nd of September, even if they had been announced before that time.
Right.
Now, there was some thought that there might still be certain other aspects of the regulations that one could benefit from. In particular, there are certain concepts known as asset stripping rules, where you could still potentially strip out assets, cash in these non-US subsidiaries and avoid some of the higher US taxes. In the notice in September, although the details of those rules haven't become clear, the Treasury has indicated they're also going to address those loopholes as well, in addition to the other aspects of the inversion rules, which include the ability, or now no longer, the ability of using what are known as sort of hopscotch loans from the non-US subsidiaries to the US parent, subscription of shares by the US subsidiary in the US Corp, in order, in effect, ultimately to reduce the amount of revenues which are subject to that higher rate tax. So those have been identified as specific areas that are going to be basically and are closed off. This has naturally had an impact on a number of these cross-border, Atlantic transactions. We saw, for example, that AbbVie pulled out of its bid for Shire PLC as a result of this. At the same time, and actually interestingly, in the same week that AbbVie announced that it was going to change its recommendation, and then soon after that lapsed its bid for Shire, another US corporation announced a bid for UK PLC, which also had tax-driven sort of inversion benefits behind that in the pharma space. So the rules haven't put off all possible bidders, and they haven't certainly meant that these deals are of no value whatsoever, but they have meant that the benefits, or the potential benefits at least, from the tax inversion loophole have been severely curtailed. And I think many companies are taking the view, or being advised, that at least at this stage, given that there's still some lack of certainty about what the full set of rules are going to look like, particularly on asset stripping, it's best to sort of wait and see. Or if there are other good and substantive reasons, other than tax, which are driving the deals, then yes, proceed. I mean, in parallel, and on the subject of tax, and what I think is also potentially going to drive some of these deals and or have a dampening effect on them, is the very recent developments in Europe resulting from the scrutiny by Brussels on what they say are potentially disguised state aids. So in the case of the UK, in fact, just yesterday, there was an announcement by George Osborne that the UK government is looking again at the patent box scheme rules, which effectively give a tax break of 10% for revenues derived from intellectual property. And having been pressurized by the EU administration and Germany really to look at that again, he announced that those tax breaks are going to be tied directly to research and innovation. So let's say from a US bidder's perspective, in a sector where there is a significant amount of revenue being derived from intellectual property or royalties, etc., not only do they need to look at sort of re-domiciliation and query whether that's going to give them all of the benefits because of the September regulations by the IRS. But in addition, they would, if they wanted to benefit from the tax break on IP, they would need to ensure in practice that the R&D operations were either relocated and or situated in the UK.
Okay, so would you say it's fair to say that you're expecting US bidders to be a bit more cautious?
Certainly. I mean, the landscape is difficult to predict, and with deals, yes, there's always an element of deal risk, but there's now quite a significant amount of deal risk if your deal is driven, primarily or significantly by potential tax savings of this nature.
Right. Okay. And after Pfizer's hostile approach to AstraZeneca, Vince Cable suggested that a public interest test should be introduced, which would give the government more power to intervene where there's a hostile takeover situation, especially where there's a foreign bidder involved, where there's very significant national interest issues at risk. What are the issues here, and are there any barriers to implementation of another public interest test?
Yes, there was a lot of heat and light following Pfizer's announcement of its possible bid for AstraZeneca, and this discussion once again of the ugly so-called foreign bidder coming to take over one of our prized assets and domestic corporations. We do already, to a certain degree, have a public interest test or basis for intervention by the Secretary of State. Just to quickly recap, the basis of intervention is now set out in the Enterprise Act 2002, which effectively limits the definition of legitimate interest for intervention to three categories: national security, plurality and standards of media, and a relatively new limb, financial stability, which was introduced in the wake of the crisis, in particular the Lloyd's HBOS bid. And those are the three very clear situations where it's possible for the Secretary of State to intervene and potentially bring a halt to a possible merger if those interests are threatened. Now, before 2002, we did have a broader public interest test, which was embodied in our Fair Trading Act of '73. And that did envisage intervention by the then Monopolies and Mergers Commission on a number of grounds, which included the relative competitive position of the UK globally. It included consideration being given to employment in the UK and the spread of industries. So much more in the nature of the kind of what I would call protectionist considerations
Right.
being allowed to be a relevant factor under the remit of the Fair Trading Act. Now, since the 70s, actually, there has been quite an active debate at times in the UK and between the political parties around the basis for intervention. And what we have seen since the 70s and then into the introduction in 2002 of the Enterprise Act and its implementation was a move away from this broader, and let's call it a more protectionist form of public interest test for intervention, to a competition-based regime which focuses on the economic impact of a particular merger, whether there is in effect a lessening of competition on the one hand, and then you have these three special sort of protected sectors, if you'd like, in parallel to that, and not the sort of wider basis for intervention. If we are today to look at the introduction of a new public interest test, and the suggestion was from this summer, we heard Shuka Muna saying, referring to it, the introduction of a new science-based test. What does that mean? Your guess is as good as mine. To date, there has been nothing concrete really in terms of what the parameters and the scope of that science-based test, and frankly, on what basis that actually affords the UK government a credible position to be able to say to the EU, which it will have to, that it's a legitimate interest that they're protecting. How is science, in sort of absolute terms, why is that sector a sector just of itself which merits particular protection over other sectors? Even, however, if let's put aside let's call it the legal speak, and I'm sure there'll be lots of clever, smart competition lawyers and others who would and have been looking at possible definitions around this. Under the regime which exists today, the UK would have to approach the European Commission if it were to introduce a new legitimate interest test in order for the Commission to assess its compatibility with general principles under EU law. And that's going to be quite a significant hurdle to get through. And Vince Cable himself, when he first started and reopened this debate in May of this year, did note that we would have to take into account the European legal framework. As the months have gone by, I think the language around that and the challenges which that presents have become crisper and clearer and much more focused in the minds of many. And indeed, just last month in October, BIS, in their progress report on the implementation of the K review, again touched on the public interest test. The tone was very much that they didn't really see a particular need for the introduction of a new public interest test. The UK has benefited from having an open economy. In 2013, 2014, as a result of inward investment in deals, there was a creation of 66,000 more jobs, 45,000 more jobs were protected. BIS talks about the fact that on average, each cross-border deal in effect adds about £187 million worth in value per deal. With this backdrop, there seems to be, just sort of politically, if you'd like, I think less appetite for introduction of a new public interest test. And frankly, I think the realpolitik of the situation has really come home to a number of people, in that it's going to be very difficult to get this through the EU, and we don't want really to battle with Europe on this.
And so it would be fair to say then, if a new public interest test were introduced, it would be more of a sort of step back, more of a regressive step than a sort of step for progress.
I think so. I mean, particularly in terms of the progress that we the UK has made in terms of its position in the global financial services market, an open economy which we have clearly benefited from, to introduce a public interest test which invariably is going to bring with it a lack of predictability and to a certain extent transparency, it would be a backward step. And I suspect also that, on further consideration and thought, those in government who were pushing for it, realized that they would find themselves in a very awkward and uncomfortable place of being pressured on a number of deals to intervene, on the basis of this new, whatever it is to be, sort of public interest grounds. And it would be a sad day, frankly, if we shut up shop and effectively raised the barriers in terms of an open economy by introduction of this test, which will invariably be a very political test. It repoliticizes this whole area of mergers.
So I suppose the question is, do we need to police these sort of hostile and also foreign bids by overseas companies? I mean, that's probably the crux of the issue.
It is, and actually, it's interesting that you use the word foreign kavita, because I think a lot of the debate, and I think it's clouded and perhaps obfuscated a lot of the debate, particularly in the media, and also what's been coming out of government, has been around the idea of the ugly, big foreign bidder just swiping up one of our domestic UK national treasures, whether it's chocolate or science and R&D. And I think the first thing that I would question, and I think it's quite fundamental, is are these truly foreign bidders, and are these really domestic UK national targets? And when we look at many of the companies that we're talking about today, which have hit the headlines, and who actually owns these companies. And today, still in the UK, yes, we do have a stakeholder concept when we look at companies, but still principally and primarily, when we talk about a company, we do associate it with its shareholders. And when we look at the spread of shareholders in both these so-called foreign bidders and these UK targets, it's a very broad mix. Many of these UK targets have 40% plus in terms of US registered shareholders. So to talk about the US bidder coming and taking over UK targets actually, in fact, very misleading. And I guess it does pick up the earlier point that I mentioned in terms of, what are the benefits of these deals? I mean, what are we actually trying to police? Now, if it is a question of, are takeovers a good thing? There are lots of papers written by very smart economists on the benefits or otherwise of mergers. And yes, indeed, there are, a recent study, for example, by the Cass Business School on US and UK takeovers, and questioning, really whether these deals add value or destroy value, and whether the so-called synergies that, many CEOs, etc., talk about when they're trying to launch these bids do, in fact, materialize. But I think, that's one debate which I think, we can put to one side. Let's, whether or not you agree whether takeovers are a good thing or a bad thing. The other issue in terms of the policing aspect, which did come out of the Pfizer possible bid for AstraZeneca, and in terms of what Vince Cable was talking about, are the concept of requiring bidders to give positive assurances or commitments about certain matters, and if they do, how to enforce them. And I think that is a slightly different issue.
Well, yes, because obviously after the approach by Pfizer and all the media storm that followed, the takeover panel sort of took up a challenge and has sort of come up with the consultation paper on post-offer undertakings and post-offer statements of intention. So what are your views on the proposals, and do you think they'd work in practice, or do you think that they would not be very efficient in holding bidders to account or making them stick to their promises?
Yes, of course there has been this very recent development in terms of the proposed changes to the code, which were, as quite clearly stated in the panel's consultation paper, and the period for consultation just ended, introduced in light of the fallout and frankly some of the confusion in the marketplace from about the weight and impact of the statements that Pfizer made. I think one of the first things to sort of note was that the code didn't then, and still does not, and would not even under the proposed changes, mandate or require a bidder to make statements of undertaking or commitments. Mm-hmm. All the code does is that with respect to certain issues, in particular around employment, terms and conditions of employment, places of business and operations, that a bidder states its intentions going forward. What the proposed new regime does is to try to address, as I said, some of the lack of clarity around the statements which were made by Pfizer. Although it didn't come to fruition and it didn't need to be tested, what was not clear to the world at large was, what if Pfizer did not stick to any of the assurances that it had made publicly in the open letters it had published, in the statements it made, in the sessions before the select committee hearings, etc.? What would be the impact of it? The new regime proposed by the panel, this sort of twofold regime, seeks to draw a very clear distinction between commitments or undertakings which are enforceable mm-hmm. in substance, at least in theory in substance, and we'll come back to how that could be affected, and statements of intention. Dealing first with statements of intention, what the panel says is that if a bidder makes certain statements of intention, and as I said, there are certain requirements already under the code where they are required to state what their intentions are, they need to do so with due care and reason, believing that they can actually fulfill those statements of intention at that time. So it does require diligence and verification at the time those statements are made. If, however, they don't fulfill those statements of intention going forward, they may be subject to criticism, some form of disciplinary action. But the panel will not, and it does not believe it's appropriate to actually require them to fulfill the substance of their statement of intention, because it is clearly, and this is what the regime seeks to do, a statement of intention. On the other hand, what they've said is that, however, if a bidder chooses, and there is choice, to go beyond making just a mere statement of intention and actually making publicly a commitment or undertaking to do or not to do certain things. And on the one relatively anodyne extreme, it could be an undertaking not to delist a company. Mm-hmm. On the other hand, in terms of a more onerous commitment, it could be an undertaking to maintain X 100,000 jobs in the UK, or retain R&D facilities in the UK, etc., etc. Mm-hmm. If a bidder chooses to, and makes it clear that it's an actual commitment, the proposed rules introduces a very strict box around which those statements can be made and severe consequences if they're breached. And the box envisages effectively that those commitments in the first instance need to be pretty much absolute, or at least they certainly cannot be qualified by reference to general carve-outs relating to a material change in circumstances. And by the way, this was one of the concerns of Vince Cable. He was concerned that, for example, Pfizer and others could just get out by saying there's been a material change of circumstances. Or there isn't an ability either to have a fiduciary out. Directors' duties mean that we can't fulfill our undertaking.
Right.
No such caveat allowed, nor is a general force majeure. There's been a disaster, another 9/11. That wouldn't allow you to get out of those statements. And you need to have flagged to the world in the documents that you publish that this is a statement of undertaking, it lasts for this period. And if and to the extent you are introducing any specific conditions or caveats around it, they do need to be vetted and approved by the panel, and they need to be very clearly defined. That sort of sets out the scope of what these undertakings could look like. The next key step, and this is a new thing for the panel, is what about the enforcement aspect? And going to your question, are these going to sort of work in practice? What's going to happen if those undertakings are not met? Well, the panel's hoping that they will really, I think, never find themselves in the situation where ex post facto they will have to get a bidder or a new group, or in fact a third party which may have acquired part of a relevant business, to unwind an action which is in breach of an undertaking. What they're suggesting is that they're going to introduce a sort of self-reporting system. So the bidder needs to effectively update the panel on a regular basis to say, we made an undertaking which lasts for 3 years, we're still committed to it, we still can fulfill it. In addition, the panel has the ability at its own discretion to appoint effectively an independent expert, similar to what the CMA has, a monitor, to monitor fulfillment and satisfaction of those conditions. The intention is that by this self-reporting and monitoring, that we can prevent a situation whereby there will be a breach of those undertakings. If, however, there is an actual breach and a commitment isn't fulfilled, the panel has indicated that it will seek to try to enforce those undertakings unless and to the extent that there is another body, for example a competition body, which is the appropriate regulator, and in those instances it may leave it to that body to enforce. But otherwise, the panel has indicated that it will look to enforce these commitments and will regard it as an extremely severe breach of the code. If necessary, it has the power to go to court. Has the panel been to court before? No, it hasn't. So it certainly is an area which is untested. If you ask any practitioner in the light of the recent proposed changes to the code, what we would be advising our clients who are bidders is certainly not to make any statement of commitment or undertaking.
That's an understandable position to take. Thank you, Selina, for your insightful thoughts on these issues, which are very topical at the moment.
Thank you.
And thank you for joining us for today's Talking Points video. I hope you found it as interesting as I did.